angels come.
I'd love to be able to say welcome to the X number annual conference. That's our Medico-Legal conference this year, but we've lost track of how many times we've held all of our conferences now. Each year, as you know, it's different, and we've had so many that we've been around since 1985. So we've been able to put on all of these wonderful conferences every year because we're fortunate to have been funded by the Bureau of Health Professions, now the Bureau of Health Workforce, at the Health Resources and Services Administration of the Public Health Service. So what I'd like to do briefly, I'm Michelle Saunders. I'm the director of the Geriatric Education Center. So I'm not only welcoming you on behalf of the Health Science Center, but also today on behalf of the VA Geriatric Research Education and Clinical Center. What I'd like you to do is open up your attendee book on the medico-legal side, not the Aging Summit side, which is tomorrow, but the medico-legal side. And if you would, you will see the table of contents and our welcome letter and the statement of attendance telling you what exactly you get in terms of CEs, et cetera, and more of those details in the next couple of pages. What I'd like to do, first of all, is to thank our planning committee. We had a marvelous planning committee this year, again, as we always do, and my staff. Those of you who have been coming for years know Barbara Giles out at the desk in the silver hair, Mark Johnson up front, who's running a lot of our AV for the conference, Joe Zapata, who is our conference coordinator, who you've met, and our research associate. We also have our Health Science Center, what Mark likes to call our stream team in the very back, Bob Merrill and Javier Escamilla, and those folks have been working with us for a long time. Our conference is streamed live every year through the wonder of modern technology, and as well we have DVDs made so that people can get those later if you want to review, or for people who missed, they can do it. Also from the VA, we have Tressa Edwards and Veronica Salazar out at the front desk also signing people in. So after the page, and Joe will explain to you about the page that has the CEs on it when he gets up here to introduce our MCs for the conference, Helen Flores and Byron Cordes. And the next page has financial disclosures, program committee list, and here's the really important page after that, if you will look at this, with the little green bar, participant profile. If you have ever filled out a participant profile for us for one of our conferences, you don't have to fill out another one. But if you've never filled one out, we have to have it. We've been able to have our conferences since 1985 for one reason and one reason only. That's because we provide data. So we need you to completely fill this out. Your name never goes anywhere, but we need it on the form so we know it's you that have filled it out, so that we don't ask you to fill it out again. But the data goes in to the feds who fund us so that they want to know where you work, how many people work at the VA, for example, how many people, so you're one of a big number of folks. It's not individualized, except for us to know that you have filled one out. So if you would do that, that would be wonderful. And then Mark Johnson has provided you with a conference CD, DVD form after that for those of you who would like audio or video, and then the rest of the booklet with the handouts for this conference on one side and then tomorrow's conference on the other. When you come out these doors, if you would go to the right to use the bathrooms as opposed to across the lobby. We have another conference going on. There's military transition conference going on behind that wall, and we want to minimize not having enough bathrooms for enough people at any given time. So if you would use the one off to the right, that would be great. And where is lunch today? Oh, okay, so we'll be next door for lunch, so that's all good. Okay, I'm going to get off the podium now and leave this to Joe to do his thing. Thank you for coming. We appreciate your attendance and your hard work. Those of you who work with the elderly know how special you are, and each and every one of you is making a difference, so thank you.
Okay, good morning, everybody. We're going to be talking about CEs real quick, and that's a very important aspect to the conference. So let's get right to it. Let's see here. If you are a VA employee, regardless of which CEs you would like, well, let's start it this way. If you're seeking VA-issued CEUs, which are the medical CEUs, the nursing CEUs, and the APA credits, and you are a VA employee, you need to go to TMS, which is the standard protocol, so you guys are used to it. But if you're trying to get VA CEUs and you're not employed by the VA, you need to pick up and complete a non-VA registration request form, which is now located and available at the front desk at some time during the conference. So raise your hand if you're not employed by the VA, but you're seeking medical credits, nursing credits, or APA credits. Okay, these individuals need to go to the front desk at some point during the conference to pick up one of these forms and turn it back into us. When you do turn this back to us, sometime next week, you'll receive an email from us with a VA email link, which we will gain access to the TMS system, because those who are VA employees have direct access because they can do it from their computers, but there's a firewall which prevents outsiders, non-VA employees to not obtain that certification and access to the internet. So that's a bit of a problem for those who are not part of the VA, but we'll try to make it as seamless as possible. For those who are getting activity directors, ALMs, certificate of attendance, guardianship, LNFAs, LPCs, MCLEs, or social worker credits, regardless of your employer, if you're part of the VA or not part of the VA, you need to fill out this form and turn it in at the end of today. And again, I'm going to be up and around all over the place, so if you need any of your VA or any of your CEU questions answered, I'm right here. I'll direct you to the point of contact. I will do anything within my power to get you guys to get your CEUs on time and in a fashionable manner, and to get all the CEUs that's possible. I know this is kind of confusing. There's a lot of different entities who are supplying CEs, and those who are non-VA, and those who are employed by the VA, and those who work with TMS, and I know it can be kind of complicated. So all the instructions are located in this booklet. And of course, for those who are non-VA and are trying to obtain via medical credits, nursing credits, and APA credits, you need to get one of those forms out in front. Again, I'll be around, so if you guys have any questions, go ahead and contact me, and I'll try to help you out as much as possible through this kind of difficult situation we got here. We're dealing with the VA credits and those who are not part of the VA. What I'm going to do next is I'm going to introduce the MCs, because obviously I'm not good at this. So our first MC is Byron Cortez. He received his master's in social work from Our Lady of the Lake University and a Bachelor of Science in Psychology from Oklahoma State University. He has worked for over 25 years in the social work field. His background includes medical social work, case management, and clinical social work with geriatrics. Byron is a licensed clinical social worker and holds an advanced certification in social work case management. He currently owns and operates Sage Care Management, which is a professional geriatric care management agency providing education and support to seniors. He's also a member of the American Society on Aging and the National Association of Social Workers. Byron has been married for 25 years and has one daughter. He is active with several local community organizations and boards. So please welcome Byron Cortez as one of our MCs. Our next MC is Helen Flores. She obtained her BS in health from UTSA in 1998 and has been in the geriatric field since then. Always a care supporter for her grandmother, it was natural for her to go to the field of elderly care. Helen started her career in retirement living, quickly moving to the Alzheimer's Association, and while there, her own father was diagnosed with diabetic-related dementia. As a caregiver for him directly, then offered training and programming while at work, Helen found herself living the life that she was preaching to others about. An opportunity allowed Helen to transition her current position at Caring Companion, a local non-medical home health agency. There, Helen has the support of her organization to offer community education in the form of being an early stage support group facilitator for those living with dementia, a master trainer in the stress vesting program for family caregivers, certified trainer for the virtual dementia tour, and the chairman of the volunteer board at the Alzheimer's Association. Helen is celebrating her 20th anniversary this year with her husband and has a 11-year-old son. So please welcome Helen Flores.
Thank you.
Something.
Good morning.
Good morning.
We have a great 2 days together. I'm very excited.
But real quickly, maybe if we can just take a couple minutes, we wanted to pantomime the entire movie of Frozen while you guys sing the soundtrack. Take just a few minutes. No. All right. All right. We're trying not to be too goofy today.
Yeah, got to keep it light.
Mm-hmm.
Go ahead, esteemed gentlemen.
No,
Well,
you get to go first.
our first session today is a panel of experts, and we have the opportunity to have their presence here with us. I think this topic is very interesting as we are going to be talking, testing for capacity. And so Byron and I are going to introduce the panel of experts for you today, and I'd like to start off by talking about Amy Bitter, who is certainly a friend of mine. We've worked together on several cases here in Bexar County, San Antonio area. She also works in Medina County, and she practices probate and elder law. Her practice also focuses on guardianship issues. So she is a frequent guest speaker at the guardianship and elder law classes at St. Mary University School of Law, and she is the member of the elder law section of the San Antonio Bar Association. She is a former board member of the ARC of San Antonio. She is married to her husband, Bruce Schreiber, and has one daughter.
All right. And the second of our three-member panel here is Russel Trey Thompson. You go by Trey. He's an experienced clinician. He's a trained neuropsychologist and been doing psychotherapy and neuropsychological assessments for over 15 years. He did receive his training at the South Texas Veterans Healthcare System, so he's one of you, not one of us, I guess. I'm not a VA employee. And so his primary focus has been on geropsychology and neuropsychology. He's well published, presented across the country, former chair of the Aging Division of the Texas Psychological Association, and he's the owner of Russel Thompson, PhD and Associates, which is a group of well-respected and dedicated psychologists. So we welcome Trey Thompson, and last but definitely not least,
Yes. We have the Honorable Polly Spencer, Judge Polly Spencer here joining us. Judge Spencer has been serving the community of San Antonio for about 40 years. She is, I shouldn't have said that, right? 40 years, but
she started when she was 6.
Exactly. On the bench for 24, okay. Well, she'll actually be retiring at the end of this year, and that will be a huge loss to us, as she has been tirelessly and diligently serving the Bexar County Probate Court 1 here in San Antonio. Been a lawyer for 40 years and has served in many capacities on matters related to mental health issues, estate planning, guardianship, and of course probate issues. She has won many awards, including the 2010 St. Mary's University School of Law Distinguished Graduate Award. She is the 2012 Avance Mother of the Year Award and 2014 Catholic Charities Lifetime of Faith and Service Award. And she has served as an adjunct professor at St. Mary's University School of Law and is board certified in estate planning and probate law. She is married to Mr. George H. Spencer, Jr., and has 4 children. So please welcome our esteemed colleagues to our panel.
The test here is, can you get up on the podium? I'm the moderator. I call on Trey Thompson to start.
Okay. So, when I got the call to do this, I was definitely intrigued and interested in the opportunity to sort of explore my perspective as a psychologist and also to learn more about the perspective of the attorney and the judge. You know, we sort of encounter one another in these cases, but we never really get to sort of go behind the scenes and talk about the processes that sort of drive what we do. And, you know, as if you've ever been an expert witness, you know that we don't really know a whole lot about what's actually happening. We get called in, we talk about our findings, and we go back out. And I always feel like I want to try to explain why I made the decision that I made, and I know that they want to understand that, but it's just not appropriate. And so I think one of the things that we're going to try to do today is sort of explain to one another how we all think about what we do. So you're going to get the opinions of the judge in terms of what are the legal definitions, how are the decisions made. You're going to get the practicalities of what is the attorney thinking about and how are they using this information. And then from my perspective, I hope to talk a little bit about the realities of actually what happens. And I think one of the interesting things when I started talking to these guys about this was, you know, they were asking questions like, well, what is it that you actually do? I mean, I know you spend hours with these people, but what's going on in that process? I really don't know. And I've heard the names of these tests, and I see these scores, and I hear you talk about your conclusions, but I don't really know what that means. So I think this is going to be an opportunity to go behind the scenes a little bit from each perspective of each profession. Now, we have here definitions that somebody else is going to talk. You want me to keep going? We haven't actually scripted this, so we each kind of contribute our parts.
You want to go into that? Okay, I can go into that. Can y'all hear me? Because I don't really want to stand up there. If you can hear me.
You can take the mic. It's taped down. There's a lot of tape. Oh, okay. Okay. We've got another. Maybe. Should I turn this off? No. You turn that one off? No.
There's a second one.
Okay, now can you hear me? Okay. Just to kind of start, this is the legal definition of what an incapacitated person is. But I thought I would read you what Webster's dictionary says incapacity is. That the entire definition for their purposes is a lack or loss of the ability to do something in the usual or desired way, which is kind of overly broad in terms of, you know, I'm sure there are a lot of things I don't do in the usual or desired way, and I would hope that I would not be considered.
But you never did.
Right. So that's not very helpful in terms of understanding where the legal issues come up in talking about incapacity. And then the Black's Law Dictionary definition is not much better. It says that incapacity is the want of capacity, or the want of power or ability to take or dispose, or the want of legal ability to act, Well, that pretty much tells nobody anything. So when you look at what the medical community is required to do in the process of a legal determination of incapacity, the perspectives are completely different. In terms of legal incapacity, obviously a minor is considered incapacitated unless their disabilities have been removed. So the minors are not really the issue, but adults who, because of a physical or mental condition, cannot substantially provide food, clothing, or shelter for himself, care for their own physical being, or manage their own financial affairs, in which case then you're led to needing to have the appointment of a guardian. Well, those are very broad also. So the testing issues that are required for having the court determine that someone needs a guardian become very important as to whether somebody is really able to do those things. As I'm sure all of you know, people can come into your office and they can pull things off really well, either because they have practiced over and over repeating the same things, and if you don't know that person, you're not necessarily going to know that that's just a pattern they have created, or you're seeing them in a limited capacity for some physical condition that they might be suffering from that could be also causing them to behave in strange ways. It might be something treatable, might not be something treatable. If it gets to the point of lawyers being involved, and we're going to ask the court to appoint someone as a guardian, we're going to need something sufficient enough to convince the judge that a guardianship is necessary. It's a very extreme measure, and we try and go through all possible alternatives to solving a problem, powers of attorney, medical treatment, all kinds of different methods to avoid having a guardianship. But ultimately, the question's going to come down, if you're in the court, to whether that person would be considered incapacitated for legal purposes. And there's a substantial number, which we'll talk about in a little while, a substantial number of rights that are lost when a guardianship is granted. So the courts are very cautious about appointing a guardian if they don't need to.
Just to tack onto that, and Amy touched on this briefly, but there are many people who are very incapacitated, but they don't need guardianships for a variety of reasons. They have other things in place. And physical incapacity, although that may be very incapacitating, is very, very rarely the basis for the creation of a guardianship, because mere inability to ambulate or even use your arms may not be sufficient to deprive this person of the rights that they have. They may well be able to manage their financial affairs and to make decisions about voting. They probably can't drive, but they probably aren't doing that anyway. Never would pass the DPS requirements. And the code requires that you have to make findings that are related to their ongoing, overarching inability to handle certain things. And as is pointed out in the slides here, but and most of you all are familiar with this, but the determination of incapacity requires evidence of recurring acts or occurrences in the preceding 6 months, and not isolated instances of negligence or bad judgment. So while all of us may make bad judgment calls periodically, this is an overarching type of incapacity. So. Yeah, we went completely out of order, but because it tied into what Amy was talking about. Trey, you may want to go ahead and pick up on some of the things you're.
I guess a couple of things that I want to pick up on are, Judge Spencer sort of alluded to all of the, I guess you could call them rule outs or the alternative explanations. And when I'm doing an assessment as the medical person looking at an individual, that's, in some ways, that's kind of what I'm doing is working backwards from the answer, and I'm trying to rule out, okay, this person looks like they're really not thinking very well right now. Can I first start by ruling out all of the possible explanations for why this may be happening that may be reversible? You know, things like a delirium because of an infection, or some other kind of illness, or debility because of, you know, dehydration, or, you know, there are a lot of conditions that a person can experience that when you first encounter them, you say, man, there is no way. And once they get some, you know, 3 meals a day and kind of stable care, then they can very much return to the previous level of functioning and look pretty good.
And I was thinking, you have several slides that are in here that are things that are specifically related to what you do, so why don't you just go through those?
You want me to jump ahead and talk?
Yeah.
Let's see, like,
Let me
okay.
say one
Yeah,
thing.
you do that while I'm doing it.
Before he talks about what he's doing when there is testing going on, from the lawyer's perspective, you've had someone come to your office and either their parent or their sibling or their child in some circumstances, you know, just depending on what the case is, that has come to you and said, we need a guardianship. And there are documents that get filed with the court asking for that. But before the court can make a determination as to whether a guardianship should be granted or not, there has to be a doctor's certificate that has been prepared within 120 days prior to the actual filing of the guardianship. And there's an example it's in the slides as well, but it's in your materials. There's an example of the physician's certificate. This is just a sample one. It's not necessarily the best one, but it's something for you to look at. That's the series of questions that a doctor is going to be asked to prepare about this person's capacity. It has physical capacity questions, it has mental capacity questions. In the case of mental retardation or other developmental disabilities of that type, there's a section for that. These are all things that have to be filled out by the doctor and presented in the court. Sometimes family physicians will fill them out. If they have good experience with the family, that could be a good source of information. But a lot of times the primary care doesn't want to fill it out for fear, number one, of offending their patient or not feeling like they have adequate background for preparing the paperwork. So often that's how Trey gets cases referred to him, because it's come through another doctor who is requiring that he do the testing. Sometimes if a person is under a psychiatrist's care, they will do the medical report, but there is never going to be a guardianship granted other than potentially a temporary guardianship without that doctor's certificate. So that is one of the things that the lawyers are going to require. And they need to work with the families in an effort to find the best person to prepare that documentation.
And just to highlight a couple things, Amy said it has to be an MD, it cannot be a PhD. MDs very often do refer to PhDs for more intensive testing and a little more breakdown of various levels of capacity or incapacity, but it must also be based on an examination that has occurred within 120 days. It's not uncommon to see the doctor's letter be dated within 120 days, but refer to an examination that occurred several months before that. It's not adequate, and we cannot grant a guardianship without that information being that current.
And another thing I want to add for all of you medical people, this is obvious to the legal people, but it may not be obvious to you, that everything we're talking about is defined by Texas law. So if you're practicing in Oklahoma or Arkansas or anywhere else, it may well be possible that a psychologist, or I think even in Oklahoma, a social worker, or I think it's a pretty wide range of people. Here we say, well, it has to be a doctor, and by doctor we mean physician, not a doctor of psychology. But in some states, it's not even necessarily a doctor. And may actually be a good thing. I mean, if you've got a social worker who's spent a lot of time with this person, they're going to be much more able to assess how well that person is functioning than, say, a primary care physician who last saw somebody a year and a half ago and, you know, checked their blood pressure and sent them on their way and doesn't really know how to assess for dementia anyway. And so there is this letter that has to be signed by an MD. As a consultant, I may get involved with that. As a social worker, you may get involved with that and consult to the physician to help them make a good decision. So that's what I wanted to say about that. Let me jump forward now and go ahead and since we've been talking about this idea of testing, I want to say some things about I want to give you my mindset of what I'm trying to do when I make an assessment. So first of all, we want to figure out, you know, using these tests, what is the right decision? And by the right decision, we want to come up with an answer, a diagnosis that is a true reflection of reality. And it's not always the case that a test score is a true reflection of reality. And technically speaking, we call that validity in the, you know, in the statistical world. And so is a score valid? That means, have we really measured what we think we wanted to measure? And a lot of times I think we run into problems because we so badly want to measure something and make a good decision that we latch onto a score. And, you know, if the test has a name in it that says this is the capacity assessment test, then, you know, we assume that if the person gets a bad score on that, they must have bad capacity, but that's not always true. In some cases, there are two kinds of mistakes that we can make. We can make a false negative decision, which means that we say that there's nothing wrong when there's really a problem. So we say, oh yeah, this person's capacity is fine, when it's really not. We've missed something, so it's a false negative. On the other hand, we could also make a false positive, where we could say, oh yeah, this person has no capacity, I have identified incapacity, the answer is yes, the person is incapacitated. And if we go back to that example of, say, reversible conditions, in that case, we would have had a false positive decision. Now, the question that I would have for you, and this is actually a question I wanted to ask my panelists, co-panelists, is which one is the worst decision? If you're going to make a decision, would you rather say, I am going to turn this person out into the world when they shouldn't be there, or are you going to say, I'm going to take away this person's right when they shouldn't have their rights taken away?
I'll say that's always a tough question to resolve, because if they have an advocate, first of all, when a guardianship application is filed, there's a requirement that the person for whom the guardianship may be created must have an attorney representing them, and we appoint an attorney. That attorney's required to receive certain numbers of hours of training, and possibly some people are getting some of that training sitting here today. But they are required by law to be an advocate for them, regardless of their personal feelings about whether or not this person needs a guardianship. Now, I will tell you, in certain areas around the state, that is more common to see real advocacy, regardless of the attorney's thoughts about the person's need for a guardianship. Around here, we have maybe a symbiotic relationship. I don't know. In any event, but not long ago, there was a proposed ward who was vehemently opposed to the concept of guardianship and told his attorney that, and his attorney worked very hard over those sorts of things. So which is the worst problem? I confess I also handle the mental docket. I tend to err on the side of caution. And, you know, if I get reversed someplace in an appellate court, that doesn't hurt my feelings, but my concern is protecting this person. And if I perceive that there's a need for protection, I'm probably going to do something about that. But if the level of advocacy for that person is such that I have no choice under the law but to grant objections to hearsay, for example. And by the way, a doctor's letter is nothing but hearsay, and if it's objected to at the time of creation of a guardianship, there is no evidence of incapacity, ergo there is no guardianship. Those are the things that we talk about. So a false negative, false positive, I'm probably going to go ahead and create the guardianship if I feel the need for protection is there, as long as I can work within the parameters of the law. So I don't know how to say that about false negative.
So I think you would probably go for the false negative. You'd be more willing to accept a false negative.
And specifically in the context of a temporary guardianship, which is an emergency proceeding, because that's not a permanent finding of incapacity. This is totally off of this point, but I just wanted to touch on that because I heard you all talking so much. I think there are a lot of VA-related people here. There's also a provision under the law, and you probably saw it in the definition of incapacity. The third criteria that's set out there is a person for whom governmental funds are to be received. And under the law, if we receive a letter from a governmental agency, Social Security, VA, which in this community, lots and lots of VA guardianships, the VA writes a letter saying the creation of a guardianship is a necessity for this person to continue receiving their benefits. The level of incapacity is of no consequence. When we get that letter, that is the threshold upon which we base the creation of a guardianship. That may be to receive only the governmental funds. There may be some other assets that might need to be managed. But I recently had an attorney objecting to that, and I'm going, it says right here in the law that when we get that letter, the guardianship is created. We don't have to do further testing in connection with that. Further testing may be done for other reasons, such as to protect other assets, but the creation of the guardianship is based on that alone. And for those of you all who have VA connections, that's an important distinction about many of the things we're discussing here, and so I thought I ought to throw that in.
I think y'all will pick up on the fact that there's a really fine line often between the false negative, false positive, which is worse, what's really showing up in the testing. When you put someone under a guardianship, there are a substantial number of rights that they lose unless the court specifically in the court order retains those. So the testing issue becomes very important as to what rights we're going to leave with a person once a guardian has been appointed. As she said, a temporary is kind of a different animal. A temporary is often used because it's always used for an emergency only, but it's often a temporary situation that will resolve itself either because there's a surgery pending and the person's going to get better, or whatever the medical reasons may be. But temporaries are sometimes made permanent when it becomes obvious as the temporary is progressing that there are continuing problems and it's not going to go away within the time frame of a temporary proceeding. So hence again, the medical testing is very important so that the judge will see, here are the circumstances we're dealing with long term. None of this is really a short-term problem unless it's in a medical thing that can be resolved. The rest of the time, these are long-term things that last at least a minimum of a year before a guardianship could possibly be reconsidered. So you don't want these documents filled out lightly because it can truly affect someone's rights.
And I would just add, as a medical person, that laundry list of abilities, voting, some of the other more obscure kinds of signing contracts, getting married, those are really hard as a medical professional, as a neuropsychologist, to answer because there has been almost no research on this. So I can't go out and look at the data and say, well, if a person has impaired memory, then we can be pretty confident that they're going to marry the wrong person.
And always under consideration, I have revised some guardianships on occasion to allow someone to be married, but always under consideration in that particular circumstance, and we're asking a doctor or a PhD to make some decision about whether or not this person can get married. That's what the question is. Okay, well, there are many, many nuances to being married, as most of you all would know. And the emotional, perhaps physical relationship of marriage can be very positive for many, many people. But marriage also involves certain property rights that are in the nature of contracts, and many people who may be under a guardianship or being considered really don't have the capacity to understand the kind of contractual nature of a marriage relationship. So to ask any of us to parse out the difference in there between what's an allowed physical, emotional relationship, and physical also brings into question other issues there. If they're younger people, physically, should they bear children? How are those children to be cared for if they themselves are of diminished capacity? You know, are you going to intervene in that? And in what way are you going to intervene? Permanently or only by contraceptive methods other than permanent? All of those are very nuanced considerations that I must say, in the context of perhaps a 30-minute hearing on whether or not a guardianship is to be created, or perhaps, I mean, I think Trey spends several hours with people, but many doctors who are doing the evaluations that we ask for may spend an hour. Parsing out that information is very, very difficult, but they're entitled to have those issues considered. Easier, frankly, for us is taking away someone's right to drive. You know, I'm often looking at people wondering, do they live in my neighborhood? And should I avoid the streets that they're driving down? Which grocery store are they going to? That's not so difficult. I also can lay some of that off on the Department of Public Safety and say, if you can pass the driver's exam, we're going to reconsider whether your driver's license should be restored to you. Very recently, I've created many guardianships that are considered total incapacity guardianships, but yet retained for the person involved the right to vote. Because you know, people with IDD, but I've been told by their caregivers, family members, that they spend a lot of time keeping up with current events. And I must say that many of them are probably better informed voters than possibly a lot of you all in this room, and certainly most of the people walking down the street. So they would be better able to cast an informed vote than a lot of other people, and I have retained for them that right, which will automatically be taken away if it's not specifically retained under most circumstances. So what he points out, and just to tack on a little bit further, we at the courthouse also are always frankly amused by the doctor's reports that we get back saying this person lacks capacity to do basically anything. The way you read it has a hard time maybe getting out of bed because they're so incapacitated, not physically but mentally, and yet they still have the ability to consent to medical treatment. And I'm going, okay, what is that all about? Does that mean they can consent to taking an antibiotic or an aspirin because they've got a headache? Or can they consent to brain surgery? It's not parsed out in there about what level of consent to medical treatment. We often just decide that that is because the doctor is sitting there eyeball to eyeball with this patient and believes that they can understand, gosh, you've got a really bad strep throat and you need to take this antibiotic to get rid of it. But I think even they would agree that if they're getting into the subject of whether or not we're going to operate and take out your kidney because you're 95 years old and have cancer, and then we're going to treat you with chemotherapy and radiation, they may not have the capacity to deal with those types of issues very well. But asking to break all of that down in a very short time period is a very, very difficult situation.
And I would just add for you medical people out there, I suspect, I mean, it wouldn't be hard to guess that the reason that the doctor wants to say it's okay is because he or she wants to help that person. And so they want to say they have enough capacity to make a decision. And if you think about that person's problem, and then what if you find yourself sitting in the chair and you're asked to make a decision about a person's capacity, and the first thing you want to do is hand them your informed consent and have them consent to be assessed because you suspect that they lack the capacity to consent to be assessed. And of course, the answer to that is that you ask for a judge to give you an order to do that, and a temporary guardian is appointed, and there's this process that happens. So if you haven't been involved with that, that's what happens. And if you ever do get called into, to make an assessment like that, that's a good question for you to ask, is there a judge who can order me to do that? Because that way the decision is being made not by the person who is potentially incapacitated, it's being made by somebody else. Going back to this false negative, false positive, I actually think I concluded wrong. I think actually Judge Spencer is saying she is more likely in the mental health court to make a false positive or be willing to accept a false positive, to say there is something wrong with this person when there's not. And I think the reason that I jumped to the conclusion that you said false negative is because I thought you were going to say false negative. And the reason is because we've had these conversations, and you were talking about sort of the national trend toward making guardianships increasingly limited. You're going to talk about that later, yeah. But, for me, when I'm trying to make the decision, in my training, I was always taught to look for the least restrictive alternative. And so when I'm looking at a person, I think that I'm going to look for, I'm probably going to be more likely to accept a false negative. If I think they can almost do it, then I'm probably going to say, yeah, I probably need to have a good reason to say that they can't do it.
And probably the real reason I said that is because I was confused about what they are.
It is a confusing thing. So shall I go on to talk a little bit more about tests? So I'm going to throw up some test names here that you're probably all familiar with, at least some of these. The Folstein Mini-Mental State Exam, the MMSE, you've heard it used in different ways. If you've been to the Medico-Legal conference before, you've almost surely seen a presentation of the Exit 25 by either Dr. Royal or Dr. Schillerstrom. If you go out and search on the internet and you try to find, if you Google, capacity assessment test, you might run across the MacArthur. There are other kinds of measures out there that if you go out and look at them, they sound really promising. And, during my training, I did all of these, and I found a lot of problems. And there, I think, in the right situation, any one of these tests can be useful, but in the wrong situation, they can be a disaster and lead to either false negative or false positive decisions. And so I've talked to the Texas College of Probate Judges a couple of times, and these are, people out in all 254 counties or however many counties there are in Texas, and some of them are out in the middle of nowhere, and there are definitely no doctors who want to make any kind of decisions about capacity. And they have a caseworker who may be a high school graduate, they may have a college degree in psychology or social work, and they're running around to these people's houses and trying to make decisions about whether they have capacity. And they come up to me after the talk and they just have this look in their eyes like, doctor, please tell me the test that I can use so that I can go out and assess these people. And my answer is, go out and get whatever test you want, but just please be aware that there are so many places that you can go wrong. Now, that doesn't mean you can always go wrong. I mean, there are some people that any one of us could spend 5 minutes talking to them, and we know that they are not going to make a good decision when we leave. But there are a lot of reasons that you can make a wrong decision, and I want to talk a little bit about that, just to kind of set the stage for you and give you some things in your mind that if you see these kinds of issues, then you need to doubt your ability to make a decision with a test that you downloaded off the internet in a 20-minute conversation. Yeah.
Just a real quick comment. we're very lucky in Bexar County because we do have statutory probate courts and very knowledgeable judges. But in some of the surrounding counties, and I'm sure this is statewide, the smaller counties, the ones that see very few guardianship cases a year, they really struggle with how to make this kind of determination, much more so than the very straightforward process that we have in Bexar County. And so if you're involved in something in an outside county, it will help the court if you are better prepared in what you're presenting to them, because they will be very grateful to you for kind of educating them as you go.
So, so these are the things to look out for. Certainly language. Anywhere in South Texas, you're going to run into a lot of Spanish-speaking people. If you're in Houston, you may run into Vietnamese-speaking people. There are, San Antonio is not as diverse as Houston or Dallas, but definitely when you run into people who English is not their first language, it's a potential problem. Now, if you're in the VA, everybody that you work with has some nominal level of English that was sufficient for them to function in the Army or whatever branch of the service. But as I'm sure you know, there are a certain group of people who come over from Mexico and sign up to the U.S. Army and can earn their citizenship by serving our country. And some of those people that I encountered when I worked at the VA, their English was a little bit better than my Spanish, but that's not saying much because my Spanish is really not very good. And so the first thing that you have to be aware of is that if English is not their first language, they may not be as able to communicate as they think they are, and as they age, and this is something I saw in the VA, as people sort of rolled back to their home community, and for the last 20 years since they left the Army, they've been living in a community somewhere in a little pocket of San Antonio where they never heard English at all. And so even though they once functioned very well in English, they haven't really spoken it practically in a long time. Another problem that I've seen when it comes to language, again, that I would warn you about, is many of the tests that we would like to use are only available in English. And so I have seen cases where well-meaning Spanish speakers, maybe somebody who grew up in South Texas speaking Spanish, within the family, but was educated in American schools and never really had formal Spanish education, tries to translate these. And it kind of works if you're dealing with other people that kind of grew up in this area. But then when you encounter somebody, say, from Nicaragua, who grew up speaking a more formal Spanish that's really quite different than the Spanish that's spoken here, your translation may be really bad. And my colleague that works in my office with me, Jesus Aranda, he actually had a case where there was this informal translation that happened, and it was a part of a CPS investigation, and this guy from some Central American country was saying he was living in the home with these children, and he said these children's father beat them and is a bad person, and somehow this interpreter got the idea that he was saying, I'm this person's father and I beat them, and he was removed from the home for like a year until somebody figured out the mistranslation. So I would caution you about language, and I think it's especially relevant here in South Texas. Another hint that you could be getting ready to go down the wrong path is education. People with a really low level of education, 4th, 5th, 6th grade, may not even be familiar with the idea of being tested. And getting a question and giving an answer is something that they have not done for 65 years, and they're not going to be very good at it. And they may misinterpret what's happening. And again, you can get wrong answers to your questions, and that leads you to conclude that this person has incapacity when, maybe they would have given you the same wrong answer when they were 25 years old.
Just to tack on to both of those, because as he's been talking, I'm thinking from my perspective, I sit about 4 feet away from witnesses in courtrooms, and I can tell when people are asked a question that they do not understand the question. But if it gets asked very many, if even the asking attorney understands that they didn't understand and tries to ask the question a different way, it's conceivable there may be an objection made, asked and answered, which is a valid objection. And so it's exceedingly important to pay attention to the language difference there and the educational level. Only yesterday, this may have been a joke, but I heard someone saying that men speak 7,000 words a day and women speak 20,000 words a day. But I was reminded when I heard that some years ago, I read a book about language in poverty. And people in poverty, that there's been studies done that they may not hear more than 50 different words a day. So you can see why the educational level, the socioeconomic level, the language barrier could make a profound difference in the way in which a person may understand a question that's being asked of them. So in your testing, you need to be very careful to try and work around that and ask those questions from a lot of different points of view until you have the sense that the person really understood the question that you're asking. With people who are incapacitated, you also run the risk of frustrating them so they shut down. So it's a real fine line to pay attention to.
And I know the next thing on his list was going to be hearing and vision problems. That is something that you also must really focus on, because often you will think someone can't answer the question properly when the bottom line is they can't hear you.
And they're compensating.
Right, so they answer what they think you said, and it wasn't the question you asked, and you checked the box that they couldn't answer the question, when if you just repeated it, if you have any indication that they might not have heard you, say it louder, or ask if they have hearing aids and are they on, or compensate for vision issues, maybe make the light in the room better. There are many things that can truly affect the way someone responds to the questions that you're asking that can lead to either the false positive or false negative, just depending on the circumstances that might exist for them physically.
And so I have this app on my phone that's, there are some hearing aid manufacturers now that provide free apps for magnifying what people say. And so I just carry around in my briefcase some headphones because I get a headache when I have to yell at people sitting across the table at me for more than 5 minutes. And so I just pull out the headphones, plug it into my phone, start up this app, and it can magnify the sound really, really well. And so I recommend if you're ever working with hearing impaired people, you find one of those. And now we're kind of going through and we're talking about these confounds in the sense that they could cause you to make a false positive, that you could say that there is something wrong with the person when it's not. But I would also warn you, and this I think again is relevant in the VA, IQ is a problem in the other direction, because you see people who are very verbal, very intelligent, very able to communicate and handle themselves like all of you. You all would be very hard to test because you are probably going to be able to come off better than you really are once you get dementia, for better or worse, right? And so when you talk about that sort of covering for hearing problems, you also see people covering for dementia problems because they're a forceful personality. You get some retired colonel, and she was ran some nursing division, and had 5,000 people reporting to her, and she is used to telling people what to do and having them follow her directions. And you're trying to tell her to quit driving. You've got a fight on your hands, and I see a lot of people nodding their heads. And those are people that definitely an in-depth formal assessment is important, because with that standardized process, we can eventually kind of see where things start to fall off the cliff. And again, it's very important. So the other kind of area of complicating factors, and these are the ones when I've got some case studies that I wanted to talk about, but these are the ones, again, that can make it very difficult to make a proper decision if a person has a mental illness that is untreated. They may make very bad decisions, they may do things that are a big problem, but if they are adequately treated, they can be quite stable and quite competent. Of course, then that gives you another really hard decision to make, which is how are you going to make sure that they continue to be treated? Substance abuse is also a huge problem. I've got a case that I want to talk about there that makes it really hard for us to predict the future. And finally, personality disorders. So, when I'm talking about personality disorders, these are problems that a person has interacting with others, and they've been that way all their life, whether it's borderline personality disorder or narcissistic personality disorder or antisocial personality disorder. These are deeply, deeply ingrained ways of interacting that people have somehow used to get through life, and now they get to the point that they're also starting to struggle. They're on their own. They've run everybody off in their family maybe. There's nobody left who's willing to even have a phone conversation with them, let alone manage their money. And even though they may nominally be able to function, and if they had a family system, they would definitely not be a good candidate for a guardianship. But if they've got nobody left and they're just kind of there on the border, it can be a huge problem. So, shall we go on through the test? Okay, I'm going to just keep going then. So now I'm going to give you an example of how things can go wrong. The Exit 25, I picked this test because a lot of you have been exposed to this, and you've seen a lot of research that showed a certain amount of success using this procedure or method for identifying executive impairment. And so some of you may have gotten the idea that this is the test in capital letters. And I just want to talk to you about how this may not always be the test. So, you do these 25 little tasks with people. And one of the things that I think, I've had conversation with Dr. Schillerstrom about this, and one of the things that he would say is that, there is a significant training process required for somebody to learn to administer the Exit 25 properly. They get their interns in and they bring them into the clinic, and they find that when people just pick up this test and start administering it, most of them are not able to elicit the behaviors in the way that Dr. Royal and his team of researchers do when they're doing the research studies that provide all these impressive statistics. So the first thing that I would say is that it does require a significant amount of training to do it properly. So let's just kind of hypothesize here that we've got this complicated subject. Say you've got a 73-year-old widowed female. She only has a 5th grade education, bilingual Spanish speaker, and she's hard of hearing. So, we're going to check off as many of the kind of problem areas as possible. So, socioeconomically, she is probably not going to be familiar with the setting. She's going to feel uncomfortable. She is probably going to fake her way through it as much as possible, but she's going to be cooperative and friendly probably, and smile and kind of go along with what you do. And in some cases, I think one of the areas that the Exit 25 is particularly vulnerable is when you have an overly compliant, polite person, somebody who is trying to interact and sort of follow the respected doctor or social worker, this professional who's come into her world, and she is very intimidated by you, and she's trying to do what you want her to do and not get in trouble. So one of the questions that Judge Spencer asked me was, well, what the heck happens during an Exit 25? I mean, what actually can cause a person to get a bad score? So I tried to lay out some of the items here to give you an idea. I mean, I don't want to violate test security here, but there are some things, this should just kind of give you an idea. And in general, the way I would describe the Exit 25 is that it is a long list of abbreviated versions of larger tests that Dr. Royal went out and identified as measures of executive functioning. And he took those measures and abbreviated them down to something that he could do very quickly in a long series. And I think that you could say that the theory behind this is, rather than testing one thing in depth, we're going to do a lot of things with the idea that this scatter shot is going to hit things. And to a certain extent, I think it works. So for example, I say to you, Okay, I want you to count using numbers and letters mixed. So you're going to say 1A, 2B, 3C. Now, can you imagine one of the potential concerns we would have with this lady that we're testing if we asked her to count 1A, 2B, 3C, if she's only gone to school through the 5th grade and she doesn't probably read at all? I mean, if you haven't ever done this with somebody, you may be surprised to learn this, but once you get to about E or F, some people have a hard time remembering what letter comes next. And so rather than testing a person's ability to kind of hold information in mind and keep track of what they're doing, you're testing their knowledge of the alphabet, which is really not what we want to know, because she never knew the alphabet and she was functioning just fine before. Same thing in number 2. What we're trying to do here is generate a bunch of words that start with the same letter. Well, again, if you're not really a good reader and you really can't read, and I ask you on the spot to generate a bunch of words that start with the letter A, you may not be able to do that very well. But you never were able to do that very well. And so, again, we're not really measuring executive functioning, which is what we wish that we were measuring. We're measuring something else. And so you can see these other kinds of, some of the things that the anomalous sentences things, where I'm going to say a sentence, but it's not quite right. Repeat after me. I pledge allegiance to these flags. But the automatic behavior that a person is going to say is what? I pledge allegiance to the flag of the United States of America. And so if a person says what they think instead of what they hear, that's said to be a failure of inhibition, a sign of executive impairment. But if I really didn't hear what you said, I'm just going to assume that you want me to start out the Pledge of Allegiance. And I'm trying to be compliant and cooperative, and so I do it. And all of a sudden, I'm tagged with 2 more points that says that I've got an executive impairment. And then the third one, there are several things where the person is, again, the idea is that if a person can't inhibit their response, if they are forced by automatic behavior to respond, then that's a sign of executive impairment. If I say, thank you, well, you would probably say, what are you asking me to, why are you saying thank you? But if you say, oh, you're welcome, I mean, that's kind of a polite thing to say, and if you don't really know what a person is doing and you're kind of confused anyway, well, you just lost 2 more points, okay? So it can be a problem. If I say, here, oh, she just lost 2 points because she took the pen. Here, I'll take it back.
I would lose points anyway because I can't do the serial 7s backwards. But one thing that you need to remember also is people's lives tend to be very patterned, particularly older people who have learned to compensate. In spite of what their disabilities may be or their incapacities, they have learned to function in a certain environment because they do it repetitively. You've taken them out of their environment, and they may still be perfectly fine on a daily basis. They can take care of their needs, they can do all those things, but you've taken them and put them in an environment and are asking them questions that are outside their norm. And so are they going to test well? Probably not. So you just have to remember, kind of see if you can judge how many times have you seen this person. If it's the only time you've ever seen them, you're really not going to know what their normal is. So it's important that you try and focus on what their abilities might be as opposed to the things they cannot do.
Yeah, and what Dr. Schillerstrom would say to that is that, this is true, the fact that someone can do the stuff that they have always done is not a sign of capacity. If the person gets up every morning, makes their coffee, goes out to the street, gets their paper, comes back in and reads the paper, turns on the TV and watches TV, none of that is a sign of capacity, because those are all automatic, well-learned behaviors that a person can do in their sleep. And what I say to people after I've done an assessment and I think they're impaired, and they say, but doctor, she gets up every morning, she makes her coffee, everything is fine. And I say, yeah, but what does she do when the coffee maker is broken and the coffee is spilling out onto the floor? What is she, then what is she going to do? And that ability to respond to the unusual is what we're more concerned about, and that's where a person is going to fail. So yes, you have to recognize that you've got a person in an unusual situation, but you also, when you're testing them, you can't act as their frontal lobes. If you provide people enough structure that they can't go wrong, if you start to say 1A, 2B, and then they go, and you go 3, you kind of hint, it's like you're trying to be helpful, you're being nurturing and empathic. You can't do that because then you're acting as their frontal lobes and you're giving them structure that if they lack that structure, they couldn't function. So you have to consider that as well.
But in the context of looking at whether or not a guardianship is necessary, providing structure that will act as frontal lobes is maybe what we're talking about. And by doing that, you may not need to wind up dealing with the courthouse and people like me if you recognize that there are deficits if the coffee pot breaks or, the house catches on fire, and you do other things to take care of that, which is, again, part of what we would be looking at in terms of whether or not you can provide other types of structure less restrictive than winding up at the courthouse. And if I don't get to sing the alphabet song, I'm not sure I can say it.
And this is why all three perspectives here is so important, because if I'm advocating for a ward, if I've been appointed as their attorney and they don't want a guardianship, and we can find ways to solve the problems they have or the things they can't do for themselves without a guardianship, that's absolutely what we want to do, and that's what the court requires us to do. So he's correct about the testing. He wants to find the things that are wrong. I'm looking at it sometimes from the other side, where I want to find the things that are right and ways we can fix it. Often, if I go to meet with a potential ward, I'll say, what do you do if there's an emergency? If you pick up the phone, what do you dial? And many times they can't say 911. They have no idea what the numbers are. But if I say, what would you do if something was wrong? And they can tell you that they would call their daughter or their son or their next door neighbor and they would come over and fix it. Well, they've found a remedy that you can act on and maybe link into something else other than ending up in a court-structured guardianship. So that's why it's real important to be able to kind of assess where those strengths and
Which is where when you identify the deficits, then you can work on trying to find ways to supplement so that you don't wind up at the courthouse.
Right, and that's where, if we've done some in-depth testing, then I actually have a reason to say, well, this person can, solve math problems fairly well. So if somebody sort of organizes their bills, they can sort of understand a budget, for example. So then we could say, okay, as long as they have somebody who's kind of looking after things, they still retain their basic values. They would, they're a cheapskate and they're not going to buy a new car until the wheels fall off, okay? It's not a sign of incapacity, that's just because they're a cheapskate. Now, I want to complain about my profession a little bit and tell you about how hard things are for me. So, yeah, thank you. Those of you who had any kind of formal testing and assessment class, you remember that when we administer a test, our expectation is that we are going to follow a standard testing protocol. Okay, so if I'm giving a Wexner Adult Intelligence Scales to somebody, if I'm giving a WAIS to measure their IQ, I can't give them hints. I can't give them extra structure, because if I do that, then if they get the answer right, I don't know if they got the answer right because of my hints or because they actually knew the answer. And if I want to compare their score to the norms that were formed by people who followed the standardized procedure, then I don't really know what I've got. And so as we're talking about all of these confounds and problems, and you're talking about, Amy, sort of trying to help people in the interview, by all means in the interview, yes. But in the testing, once things go south and the person doesn't understand, if I go back and I start helping them, then I get a score that is not really reflective of what I think I'm trying to measure. If I get an IQ score, and really it's half my IQ and half your IQ, then we don't really know what the person's IQ is. Well, yeah, I mean, there's only so much we can do, but so in that case, that's some of the reason that I would argue that one test is not adequate, because I can't tell you how many times I was in the hospital and I'm testing somebody's ability to remember a list of words, and I'm reading 5 words, and I get through word number 3, and the nurse comes in and says, okay, it's time to draw your blood to find out your insulin levels, and I don't even get through the 5 words, and then I don't get to ask them if they remembered the words, and that whole test is just ruined, and in that case, the only thing I can do is go on to the next test. So that's one of the reasons, if we give several tests, even though there's going to be some variability and some interference from the environment, if I give enough tests, then the problems are going to average out. And if the person fails 2 or 3 tests of the same ability, I can feel more confident that I've gotten the right answer. So, okay, so with the exit 25, any score above a 14 means that you're impaired. And so we've got this red line here. And I first gave you a graph of somebody who's okay. They got a few things wrong. They were maybe a little bit overly compliant. But this is why we have a normative value that's set by research, because we know that everybody is going to have a few things that are wrong. And so the fact that you get a few points on the exit 25, that doesn't necessarily mean your executive functioning is impaired. If you have to sing through the ABC song and you get interrupted along the way and you miss that item, you get 2 points, okay? If you're overly polite, you say you're welcome after I say thank you, you get 2 points, okay? So the assumption that we have with any of these tests is that we set a cutoff, and if you fail, it's because you've gotten more wrong than the average person. And the idea is that this incorporates the kind of normal variability that everybody has a few, we all have a little bit wrong with this. I'm willing to admit that before this whole group. Okay, but now here's where things get bad. Let's say you've got somebody who has a few problems. We've got our 73-year-old lady. She's not functioning as well as she used to. Maybe her true score, if we really had a magic wand and we could extract her true executive functioning ability on the exit 25, let's say she gets a 10, okay? A 10 is below the cutoff, she's fine. Now let's say that we bring this lady in and she is overly cooperative. And now she only gets to make 3 of those overly cooperative mistakes, and we've gone from somebody who's normal to somebody who's impaired. And so, when you first look at this list of items that I made, and you say, well, you can get through a few of those, and I can see how a person could do that, but that's no big deal. The problem that we have, though, is we have people, we're not going to be talking to them unless they have a little something wrong with them at least. And so then you have a little something wrong with you, and we make a few mistakes because of their intelligence or language abilities or hearing and vision problems, and all of a sudden we've made the wrong decision. And so this is kind of my big reveal in terms of why we have to worry about these confounding factors and why there is no one test that we get one score, or if you're going back and looking through the records and you see one time when a person failed, you don't know anything about that testing situation. You don't know somebody gave the exit 25. Maybe they downloaded it off to the internet the same day that they tested this person. It was the first time they gave it. You have no idea. So, sort of taking one of these scores and turning it into some kind of, reifying it into some kind of golden standard is a huge mistake. So, okay, so we've got all these problems I've told you. I've told you about how hard my life is and how difficult my job is. So, and how hard your job is going to be when you try to go out and do this stuff. So what now? And my answer would be, if you see these kinds of things, you need to be considering in-depth testing. You need to be thinking about, so this is the slide that I want to show to those people from the surrounding counties who say, well, how can I go out and make a good decision for all these people? I've got 50 people I've got to take care of this month. How am I going to do it? And the answer is, if you go out and see somebody and you don't see any of these problems, and you give the MMSE, or you go and look in the records and you see that they've failed the MMSE, then you can probably feel pretty confident that you're making the right decision. But if you see all these things, every one of these things that kind of stacks up, you should be feeling less and less confident about your ability to make a good decision. All right, so we got to go back and what's next? What do you guys want to talk about?
You want to talk about the process and
Okay.
just how you do. Just for those of you who are not aware of this, there are several distinctions to be made here. First of all, and Trey has mentioned this several times, the impact of a psychiatric illness. When I'm, for example, I go out and talk to a law school class fairly often about creating a guardianship. You need to draw a line between when there's a need for a guardianship and when there's a need for psychiatric treatment. And or substance abuse treatment, which is woefully lacking in this community and in Texas, because they decided a few years ago that it wasn't a mental illness and they were going to pull it apart from mental illness and not fund it anymore. So good luck on getting treatment for substance abuse. But the concept of the psychiatric illness, and he's touched on this several times, is that a person...
You want to try this one?
No, this one's still on. I think he just turned it down some. A person can be very, very impaired when they are in an acute exacerbation of their psychiatric illness, but with proper treatment, they will be pulled back up to a level of functioning that's acceptable in society. Possibly not the way we would like to function, but still able to get along. That usually, one would hope, is a short-term issue that can be treated properly. So when presented with that concept, as he pointed out several times, you need to always be trying to identify whether this problem is a psychiatric problem that appropriately medicated would resolve that issue, which means then you need to seek out ways to do that. Ultimately, you may wind up again at the courthouse seeking court-compelled mental treatment for a mental illness. And there's a whole huge issue there. We have in this county actually about 5,000 cases filed a year for the treatment of mental illness, and those hearings are conducted, actually most of them are conducted by an associate judge who works with both of the probate judges here, Oscar Kazin. And just as an aside, he mentioned also that, yes, you receive treatment for your illness, and virtually every psychiatric facility is required to release people when they have reached a level of functioning that no longer requires them to be inpatient. But we have in this community a very, very active program of court-compelled outpatient treatment, which frankly has become a model for the entire United States, and Judge Kazin mainly oversees all of that. But we do have some options to encourage people to continue receiving psychiatric treatment, even though they're no longer inpatient. But the concept of receiving treatment for that particular problem is that it can be treated, you can be brought back up to a level of functioning that would mean you're not so impaired that you need to be at the courthouse. Guardianship anticipates a level of functioning that is broad, overarching incapacity that's not likely to resolve either at all or any time in the near future. I'm going to talk just a little bit more about this in a few minutes, but people who are mentally retarded, IDD, that problem is not likely to get better. That's because that's the way they were probably born, that's the way they're probably going to stay, and then providing them appropriate support so they can be in the community in some way or another is something that we look at, and hopefully a guardianship allows some structure to be surrounding them. People with dementia likely are on a downhill course. They're not likely to, that's an overarching problem. Their judgment is probably going to continue to get worse instead of better. And so that's the type of a problem that will often wind up in a guardianship. A person with a stroke, we may not know for a while what their level of functioning might be after they are treated for a stroke. Go through rehab process. They may be pulled back up to a level of functioning that will put them either in a very limited guardianship or out of a guardianship. Completely. Head injuries are another example of that. If you are able to treat the head injury and bring them back up to a level of functioning, they may need a guardianship for a little while, 2 or 3 years perhaps, and then they may not need that. But when a guardianship, if you need to get someone treatment for a psychiatric problem, you need to go down and fill out papers, swear out an affidavit saying that you have these circumstances. And in virtually every place in this state and in the United States, you have to allege that there is an imminent threat of danger to themselves or other people. The mere fact that they are very incapacitated and very debilitated just in terms of their ability to get along in the community is not sufficient to force somebody into psychiatric treatment almost anywhere. And it's a sad circumstance, and we listen to people tell stories about that all of the time at the courthouse. She won't bathe, she's, wandering around in the middle of the night and all of those sorts of things. Until you allege danger, true imminent threat of danger, you're probably not going to wind up with any kind of court orders that are going to assist in treatment. People have the right to be crazy in the same way people have the right to make unwise decisions about their health. People who are diabetic don't eat properly or exercise. A lot of people are aware that smoking can be bad for you, but I bet you could go outside and find some people smoking now. We don't jerk those people off of the street and require them to go get treatment in the same way we cannot do that for people who have a mental illness unless it arrives at a point of danger that society has said, after you cross this line, this is unacceptable, we're going to do something about it. To start a guardianship, an application gets filed. An attorney's appointed for the ward. There must be this medical information that we are discussing. The ward has to be served with papers, either through a private process server or through the sheriff. And through the years, I've had many families go, I understand and maybe I need to do something, but I am unwilling to do that because I don't want the sheriff knocking on mother's front door and handing her papers. And that's a requirement. Can't be waived. Absolutely has to be done. The attorney is supposed to investigate. We have a hearing. There needs to be evidence of incapacity. Again, what I mentioned earlier about the medical certificate, which I think Amy's going to talk about in a few minutes. Most of the time around here, that medical certificate is either presented at the time of the hearing or has been filed, and it details a lot of information there. That medical certificate, I'm not even sure this one requires it to be notarized, but that medical certificate, as I mentioned earlier, is nothing but hearsay. It is an out-of-court statement being received for the truth of the matters asserted therein. And if the attorney ad litem for the ward objects to that certificate as evidence of incapacity, they object hearsay, sustained, no evidence of incapacity. It doesn't matter how much lay testimony you may have there, how many people might get on the witness stand and testify. If they are not MDs, it's not going to do any good. We don't have medical evidence of incapacity. So for lawyers, I would suggest that you be in contact with your attorneys ad litem to just be certain that they are willing to have you admit the doctor's certificate into evidence, because you have to have that evidence. For attorneys ad litem, at least in this community, if you intend to object to that, which you might be required to do because your client does not want a guardianship, and it doesn't matter how much you think they need it, if they don't want that, then I think it would be just courteous to let the filing attorney know that you're going to have to object to that certificate as hearsay so they can arrange to have the medical evidence presented probably live on the witness stand at the courthouse so that they've got the necessary testimony there. You have the hearing. We are required at the courthouse to make a finding by, there are 3 evidentiary standards. There's Beyond a reasonable doubt, which is the criminal standard. There's preponderance of the evidence, which is more likely than not, which is the general civil standard of evidence. And then in this case, there's a required finding of incapacity by what's called clear and convincing, which is a standard of evidence. And you can get into a lot of esoteric stuff about, evidentiary standards, but clear and convincing is a level of evidence that is between preponderance and beyond a reasonable doubt. The finding of incapacity must be made based on clear and convincing evidence. To have someone put in a psychiatric facility, we have to find all of the things that are related to that by clear and convincing evidence. And I think you can see why that would be true. It's a significant taking away of rights to put somebody in a psychiatric facility, to put them under a guardianship. Amy will talk a little bit more about whether it's total or partial incapacity, and then I'm going to tack on something about that, just that I know that's going on legislatively that goes on all of the time. But a finding of total incapacity means that the guardian is then given full authority to make all of the financial and personal decisions for this person, and the ward no longer has those decisions. We usually recognize that the guardian will consult with the ward about what they want, and I will tell people, talk to them about this and what it is that they want. And to the extent that what they want is not unreasonable, even though it may not be what you might choose for yourself, let them have that freedom there. But ultimately, as guardian, you get to make these decisions. That's really pretty easy because that happens all of the time anyway. Total incapacity is what most guardianships wind up being. When that happens, there are many rights that are taken away from them, but specifically their right to drive. There's a required notice to the Department of Public Safety. Their right to vote. There's a notice to the registrar, the voter registrars, and their right to own a firearm. Personally, that doesn't give me heartburn, but for some people that does give them heartburn. But we're required to notify the Department of Public Safety about those sorts of things. When you get into the nuances that are related to partial incapacity, it's much more difficult to parse those out about what rights should they retain, what rights should be taken away from them, how much supervision do they need, and all of those sorts of things. Then the final, you have to make the finding of incapacity and the level of incapacity, and then there has to be a guardian appointed. We have many people for whom it's clear a guardian would be desirable, but we don't have anyone to serve as guardian. That's an ongoing issue. We're trying to work on that right now because those are people often with a personality disorder coupled with a substance abuse problem and maybe an onset of dementia and probably a psychiatric illness, and every bridge they ever crossed got burned a long time ago. And you can call their family and they'll go, not only no, but hell no, and don't call me back, and I'm not answering your phone calls anymore, and they don't. And trying to help those people is a very difficult issue. Still believe we can help the world get better, so I'm still willing to get involved in that, but it's hard to sort those things out. We have to find, there has to be a guardian. Most of the time, for most of our guardianships, the application gets filed by a family member some way or another, and we go through some qualifying questions about whether this person is qualified. There are levels of priority about who gets to serve as guardian, basically. It's levels of family member, a spouse, children, maybe siblings, next of kin, parents. There's a laundry list of people there, and they are entitled to serve as guardian unless they are disqualified. There are several disqualifying factors. One of the most common that we run into between parents and children is that the child owes the parent money, and if they owe the ward money, they are disqualified to serve as guardian. Very often that problem also gets solved by them finding a way to repay mom the money they borrowed before we actually wind up in the courtroom to address the concept of disqualification for guardian. There's several other things in there: sexual offenses, terroristic threats, APS reports, CPS reports, unsuitability, one of my favorites because it's a way I can get rid of people who shouldn't be serving as guardian if I get enough evidence to go, oh gosh, too bad, you can't serve as guardian, unsuitability. In this community, we require bonds, corporate bonds, of everyone who serves as guardian. The code requires us to make people put up a bond. Sometimes in other communities, they may put up personal bonds. Those things are, in my opinion, worthless, but I know in smaller communities that sort of thing is done all of the time. A way to disqualify a guardian that I can't otherwise disqualify is to realize that they are unlikely to be able to qualify for a bond. Lawyers have come before me in the past going, Judge, we need this guardianship, but we want to get the bond waived because my client has credit issues and we won't be able to get a bond. And I'm going, so you want me to turn over control of someone else's money to someone who has significant credit issues and not have it bonded? That is not going to happen. And occasionally when I've had warring siblings in who are equally qualified and or disqualified, in my mind, I have said, I'll go through a hearing for 3 or 4 hours to decide whether they are unsuitable. But before we do that, you lawyers go out and bring back to me a letter from the bonding company saying that each of your clients would qualify for a whatever $60,000 bond before I spend 3 or 4 hours of my time and yours and possibly Mom's money fighting over these issues. So that's the process that has gone through. After a guardianship is established, you can have a guardianship of the person where they make personal decisions, medical decisions, residential decisions, those sorts of things. You can have a guardianship of the estate, which controls the money. You can have a guardianship of both. You can have certain co-guardians in certain circumstances, generally husbands and wives. You can have a sibling for person, a different sibling for estate, all of those sorts of things. There are reports that are required to be filed, but that's a process related to guardianships that I think it's important for everyone to understand. So I thought I'd go through some of that. I'm not sure that's in the, well, I know it's not in the PowerPoint, but I wanted to talk on it. So you're going to talk about the...
Okay, we're going to talk.
Can I just ask one quick question?
Yes.
I'm going to delay. I'm sorry. I have a question. One of the things that I do when I assess people and I say, I think you have mild cognitive impairment, I think that there's a risk that you will become demented at some point, I recommend you go find an attorney, get a durable power of attorney so that you get it down on paper who you want to make decisions for you. How does that factor into this whole process? Is it always a slam dunk at that point? Does there have to be a legal process? Does it sometimes have to get reversed, or what happens at that point? Is that I mean, I think that's a good thing. Is it a great thing or an okay?
At least from the lawyer perspective, that's a great thing if those people still have the ability to sign the documents granting authority to third parties. The question becomes, are they already advanced enough in their incapacity to not be able to understand what they're signing in granting that power to somebody? One of my favorite, not really, but humorously favorite physician certificates to receive is the one that says that the client is, or the patient is completely incapacitated, but then they check the box that they can still sign a power of attorney. Well, if they're completely incapacitated, they no longer have the ability to sign those powers of attorney. So it depends on what level they are. Absolutely, powers of attorney are less restrictive than a court proceeding, and you want those. It's just a matter of whether that person can still sign them or not. Is it too late?
And as we all know, it's really who wants to fight over it. As long as you can get the powers of attorney and everybody's cool with operating under those powers of attorney, it's fine. If you have the siblings warring over who gets to control the money with the financial power of attorney, or sometimes it happens over the medical power of attorney because the sister can't bear the thought of taking mom off life support and the brother is easily able to make that decision, because sometimes we suspect what they really want to do is fight over the money and not fight over who gets to make decisions about mom's care. So the answer is, who wants to fight over it? They're often going to go back and look at those determinations when they're having the will contest later on. Well, it says right here that on this examination done in February that she was totally incapacitated. So that means documents that were signed in November must have been not valid because she was totally incapacitated. What some people will overlook in those circumstances is that in January she had a massive stroke. So it just depends on the circumstances, and but always it's helpful if you all believe that there still is sufficient capacity to make a decision about giving someone else the ability to make decisions with or for them instead of having to wind up at the courthouse. So I see a question over there, and we do want to do some questions in a few minutes. But you can, if you want to go ahead and raise your question now, or we'll try and tag off and hit questions.
I had a question about these power of attorney, Your Honor. If somebody's done,
Why don't you stand up so that we can be sure everybody hears?
I had a question about the power of attorney, Your Honor. If somebody's done a power of attorney, if we all go out and do powers of attorney today, we're 40 years old and presumably we don't have mild cognitive impairment. Should that spare us the need, should this be a springing power later in life when we get demented? Should it spare us and our families the need for going to court and guardianship? That's my understanding of executing these documents, is getting around all that. If we all race out to our attorney's offices now and do a powers of attorney, that we shouldn't need these things when we all get the birthday disease and the Alzheimer's later in life. Or can our siblings and children fight over that later?
There's absolutely no lock on the door of the courthouse, and so people can fight over anything they want to pretty much any time they feel like it, and they do. To get a power of attorney, you absolutely should do that sort of thing. Will it prevent these sorts of fights? No one can guarantee that, but it's a good step to take in connection with that. I personally am not in favor of what's referred to as a springing power of attorney, which takes effect only in the event of incapacity, because that will require a determination by someone to say this person lacks capacity, and the usefulness of that particular document may be somewhat inhibited by whether or not, for example, the bank or the medical professional is willing to take it without that supporting documentation, which puts you back into the cycle we're trying to avoid. But a lot of people don't want that.
Okay, are we back on? Okay. From the lawyer perspective, in terms of powers of attorney, absolutely you want your clients to have powers of attorney to at least attempt to avoid all of this issue. Sometimes it won't avoid it because a bank will say, oh, that's not on our form. We can't take that. Well, under the law, that's not technically correct, but if that's the bank's policy, then you're sort of stuck with it. As far as the springing powers, I give my clients the choice when we prepare them, but I agree with the judge. I don't like the springing ones because there are still factors that have to be dealt with down the line. You still have to get a doctor or two doctors. I think most of them say 2 doctors have to have agreed that the person's incapacitated. I have an issue like that now where the clients have come to me and dad is doing crazy things with money, and that's not the kind of thing he would have ever done, and there's clearly some incapacity there, but none of the family physicians or primary care or anyone except the eye doctor are willing to sign something that says that he's incapacitated. So the whole issue is, how do we get him, you know, even though those documents exist, they're not helping in this particular case because it was a springing power. My suggestion to clients when we are preparing powers of attorney is don't put someone on that document that you don't trust right now. Because if you're in a car wreck tomorrow, that person needs to be able to act for you, or whatever the circumstances may be. I think springing ones are dangerous, but that's just my own personal opinion. Yes, ma'am. Yes, there is a, she was asking about designation of guardian prior to the need. It's a document we all call a pre-need. When you're preparing powers of attorney, at least it's in my practice, I always ask the clients if they want this. I don't force them to do it, but most of them see the logic behind when you're signing your documents. You sign a document that says, should I ever need a guardian, here is who I want, and here is who I specifically disqualify. And the courts will look at those. If the case ends up in a court because the powers of attorney aren't effective or whatever the case may be, they're going to look at what you said back when you had capacity as to who you wanted to act on your behalf as guardian. You can designate both guardians of the person and guardians of the estate. So if you have one child that you absolutely want to make medical decisions for you, that's who you designate. And if you have one child that you absolutely do not want touching your money, then you disqualify that person in that document. So just so the medical professionals here can understand, there are a series of documents that should at least be discussed in the lawyer's office when all of these things are being looked at. Declaration of guardian in the event of later incapacity, I think is the correct title.
So let me ask a question. When I do an assessment of someone, when I do my interview, a lot of times it'll be with the husband and the wife, and they don't have a durable power of attorney, and I advise them to get that. But one of the things I try to do in my report is I try to, I'll ask them, well, who would you want to make your decision? Who would you trust? Who would you not trust? And I document that in my report at the time I did the assessment. Is that a waste of time? Do you ever refer back to that? Would that be helpful?
I think it would be helpful because they've actually expressed those desires. Even in a circumstance where a guardianship has been filed, the court will ask the ward, even if it is absolutely clear this person is incapacitated, if they have a preference. And if it is a reasonable preference, then the court takes it into consideration. If it's the yard guy who's been scamming money for the last 2 years, the court's not going to take that into consideration, obviously. But part of the procedure is that a ward is going to be asked. So if they have made that determination prior, it is very helpful to the court. Because a lot of times if in the hearings, you can't get them to say anything, or they don't understand the question, or whatever the case may be. But if they have made that declaration prior to the incapacity, it is certainly helpful.
What's the role of the physician in a standard power of attorney then? Classically, my experience is the potential ward doesn't want a guardian, doesn't want the power of attorney in effect. There is no springing document, but the bank says, hey, mom's telling us you don't have control over money, and she wants to give it to the gardener. And she wants to run away and marry him or whatever. So they'd like to drag our office into it. And we want a letter, involving the medical office. What's our role? What does the court need from us? To say, hey, yeah, mom's incapacitated. Go see Dr. Trey. Let him sort it out.
As a medical professional,
Yeah.
If you are concerned about the circumstance you're looking at, there are multiple things you should do. You can call APS, sitting right back there, and make a referral. I believe that I'm correct in saying that if it's financial abuse that you are perceiving, they are not as likely to act on that as rapidly because they are
But it's a clear-cut case, Your Honor. The patient's incapacitated. They should have the power of attorney. The power of attorney is right there. They should have the power of attorney. It should be invoked now. How does it get invoked short of coming to you and making a guardianship out of it?
Well, and you're there with mom and the yard man?
Yeah, and the daughter. And nobody in town wants to honor the thing.
Well, they should honor it.
Ross Bank doesn't want to honor it. They don't understand. They haven't come to the seminar.
Actually, there's some banks that understand a lot better than others. But it may be another thing that can be done is make a referral to the probate courts, and we will take some action trying to look into that.
Mom wants to write a big check today. Big. Hundreds of thousands today.
And, you know, I mean,
She wants to put it on the doctor. Marinelle Maloney wants to call me and, you know, Marinelle doesn't think people have the right to be crazy. She'd like to make it my fault if she goes and does something crazy.
Well, as I said, people do have the right to be crazy.
And the right to sue me
and
if I
you
don't
know,
settle it.
And a bank may look at that and be wary of the circumstances, and there are several banks that will go, you know what, this is making me a little bit nervous, and they will make referrals to the court. If they're aware of a potential agent under a power of attorney, they might make a contact there. But you just have to rely, frankly, on the common sense of a lot of people that are acting there.
But it's so uncommon, the common sense.
Well, and as I tell lawyers frequently, there's no requirement that you check your common sense at the door when you get involved in some of these, and I don't dispute. And that circumstance you're describing, unfortunately, happens with far too much frequency. And I would make actually every referral you can think of there, including calling the daughter, writing a letter to the court, calling APS, and possibly following up. They actually do in the district attorney's office follow up in some circumstances on that type of elder abuse, that financial elder abuse, and they're becoming more active doing that. Are you going to be able to stop the money from going out the door that day?
I believe, yes, we have.
Good.
Okay, two things kind of on that same subject before I forget. In terms of referrals, the judge is talking about both courts have investigators, and if you are concerned about the capacity of someone that you see, please make a referral by calling the courts. You can email. It doesn't even have to be a whole letter. Or send a letter to the court that says, here are my concerns, here is the person I'm concerned about, here's the information I have about them, because the court will take action to appoint a guardian ad litem, which is different than the attorney ad litem, in order to go investigate whether or not a guardianship is in the best interest of this person. And in a lot of, I think the medical profession sometimes sees instances that the lawyers don't see because somebody has to come to our office for us to see them, but those people come to you. So if you are concerned about somebody's circumstances and whether they're being exploited, please make the effort to refer to either of the probate courts in Bexar County. And the other thing, just to throw a little kink in the power of attorney world, someone who is incapacitated can actually revoke their powers of attorney, even if they're incapacitated. So a lot of the work that you've done might be undone by one quick instance by the ward.
That's true. That's specifically in the Medical Power of Attorney Act, that they don't have to have capacity to revoke that. And just as an aside, the mere fact that someone is under a guardianship does not mean they cannot write a valid will. They may not have capacity to contract, but it's generally thought that the capacity required to enter into a contract is a higher level of capacity than that might be required to write a valid will. So to have someone say they're under a guardianship, this will can't be valid because it was signed while they're under a guardianship is not necessarily true. That's a focus on that exact instant of time. Also touching back on what I said earlier, the mere fact that someone's been involuntarily committed to a psychiatric facility is not a sine qua non for a guardianship. Health and Safety Code, which controls mental health commitments, has a specific section that says the determination of incapacity must be made in a probate court in a probate proceeding, not in a mental health proceeding. Do you want to touch on that or would refer them to that capacity letter?
Okay, real quick, this is just a sample. We're gonna go through some of these questions on the second page of the physician's certificate where it talks about the evaluation of the proposed ward's mental function. It's very important that you don't just go through and check boxes. You need to actually understand what the question is asking you. So in these evaluation questions, would the ward understand the proceeding if they were brought to court? Would they understand that somebody's about to be potentially appointed as their guardian? If the answer is absolutely no, sometimes their appearance at the hearing is waived. If it would be physically, if it would be very physically difficult for them to be there, it can also be waived. But most of the time, you have to have your ward present at the hearing. So you need to determine whether that person could really understand the proceeding or not. If they have had some debilitating stroke and they're on a ventilator in the hospital, obviously we're going to waive their appearance at the hearing. They can't be there. But if somebody just is so far gone in the dementia scale that they really, to even leave their environment at a nursing home or that kind of thing would be so disturbing to them, then we're going to waive their appearance. But for the most part, they have the right to be at the hearing. So these evaluation questions are very important. And the decision-making questions, are they able to answer questions? Do they take medication that could change how their responses would be? These are all things that are really important when you're assessing these questions. Medical providers don't always know whether somebody has the ability to make financial decisions or not. But if you can glean something, if they can't count change, then you might clue in that they might not really be able to write a check, pay a bill, that kind of thing. So all of these questions need to be looked at individually rather than just check. Don't just check all the boxes yes or check all the boxes no. Very carefully go through each question. And then in terms of whether, this is on page 4, sorry, I'm going ahead. Checking the box as to whether it's total or partial incapacity. Total incapacity means the court is going to be looking at appointing someone for every possible decision that can be made for that person. Partial gives us some freedom to retain some rights in the ward. Can they still vote? Can they still drive? Surprisingly, we have done that. If somebody is capable of truly operating a motor vehicle and making okay decisions that way, there are cases in which we have retained the right to drive. Right to vote in elderly people, they find that very important to not lose the right to vote. I'm trying to think of other rights that sometimes we specifically retain. Choosing residential preferences, that kind of thing. If that person can really give you logical reasons and back it up as to why they should live one place versus another, then they need to be able to maintain that question. So please know that we provide you with a form if we're asking for someone to fill these out, but it's not just a rote check the boxes. Please be very careful in how you fill them out.
And just touching on the residential decisions, if you ask mom, does she want to continue living at home, I bet the answer 99% of the time is going to be yes. That may not be the best environment for her, or she may need sufficient structure in that living environment that would require a great deal of expense. Sometimes we suspect that the children do not want to spend the money to provide the sufficient care for mom at home, because that diminishes what they might expect when mom passes away. But we always have to remember that it is, in fact, mom's money. So it's not their money, and they don't get to act like it is until it becomes their money, and that's usually after mom dies. So sorting out those sorts of information. Now, some people need to be in a care facility regardless of their ability to pay for around-the-clock care at home for a variety of reasons, including the social stimulation that goes along with that. There are just a couple things I want to touch on quickly, and then we can take just some questions. Because of some things that I've been involved in, kind of that are statewide things, and this happens all of the time, I just know that in the IDD community there continues to be work done on how you can provide sufficient protection for people who are intellectually disabled, to provide protection for them, but still give them adequate freedom to do the things that they are able to do. And I know that there's work being done on something now that's called supported decision-making, which allows a person who has some capacity but possibly diminished capacity to sign a document that says X, Y, or Z is the person who will assist me in making decisions. I know that there's going to be a bill introduced about that. I know that's been done before. I have a concern about that, is how do you control that as far as having family members do that? My observation is they allow this person to make lots of decisions all of the time. I'm a little bit more concerned about the next door neighbor or the yard man being that person, but there is a mandate to report to APS if you have a concern like that. No, that's coming up. There's also a Bill of Rights that's been prepared for people who might be under a guardianship. I personally have a problem with that because there are a couple of things that are in there, such as the person under guardianship has the right not to be involuntarily committed to a psychiatric facility. Well, in my opinion, no one walking down the street has the right to be not involuntarily committed if they meet the criteria for involuntary commitment. So to write that into a Bill of Rights and make it a prohibition doesn't make sense to me. Also, a person under guardianship has the right to manage their property. Well, why put them under a guardianship if they have the right to manage their property? But I know that some of those things are in this, and the point of all of that is that I know that people are working hard to try and define levels of incapacity so that protection can be provided while still retaining a lot of self-determination rights. Those things are going on statewide. I also know that there's work being done for some smaller counties to try and look into the ways in which they are managing guardianships and to provide assistance to courts that don't do that all of the time and don't follow up with the guardianships and don't look at protecting the ward for whatever reason, providing the reports that are required, looking at whether the guardianship should be continued from year to year, all of those sorts of things. I know that's going on in smaller counties, and I'm sure there's some counties where they don't bother with such things like medical evidence because the county judge goes, well, everybody knows that old Joe is crazy, and he always has been crazy, and that's how they get into guardianship. So those were just some things I wanted to touch on briefly, and I don't know whether there's any more time or whether there are any more questions.
We have just a couple of minutes, but if I could remind folks to wait for the microphone, because we're recording it, and there are people watching online, so without the microphone, they can't hear you. So, sorry, she had her hand up first. Nice.
Your Honor, I had a question. Texas is one of 4 states that are not honoring guardianships from other states. Could you help me understand why that's occurring? I'm trying to understand why the state of Texas has chosen not to honor guardianship paperwork from other states.
If y'all heard, she says that Texas doesn't honor guardianship paperwork from other states. What happened, there is a provision for having the documents that have been used to create the guardianship in other states be transferred here, and then we review them to really create a new guardianship here. Now, I don't know whether you're talking about a guardianship that's in Colorado, for example. Well, and well, and actually, I'm not, we probably need to talk about that more specifically, because I actually would say that when you get the documents transferred down here, we're probably not going to go through a redetermination of incapacity. We're going to look at it to be sure that, for example, the guardian's properly bonded and that reports get filed. But generally, we're going to receive those guardianships from other states to take care of that concern. So if you've had a problem with that, I'd like to know the specifics on that at a different time. Are there other questions?
Well, actually, if I can, we have our, is this on? Yes? Hello? Okay. We have our distinguished guest, Nelson Wolff, who is on a time schedule, so we're going to quickly introduce him. We're very honored today to have Nelson Wolff here with us. He's county judge, of course. He's been in public office since 1971, when he was elected to the Texas State House of Representatives. Excuse me, fighting a cold. Then he was elected to the Senate in 1973, San Antonio City Council in 1987, and then served as the mayor of San Antonio from 1991 to 95. He currently serves as the county judge since 2001. He has a law degree from St. Mary's University. I can barely read this, sorry. And of course, I think, I'm not sure I need John, and I think he's here. He said to introduce him. And so, here's Nelson Wolff, please. Clap, maybe he'll come. Psych, okay. I think he said introduce Nelson Wolff. He could be. He wanted to make a grand entrance. Maybe they're opening the doors for him. Please tell me that's it. Feeling a little silly. Yay. All right. Woo. They were about to get some really bad jokes, Judge. Okay. Okay. We'll take it. I'll hand this over to you.
Oh, we're going to do it right here?
You bet. Wherever you want. Or you can stand up here if you want. We'll plug it in.
This is okay. This is okay. You can look at my notes as we go. Well, thank all of you for being here for this conference. I must tell you this morning I got some very exciting news. My staff had worked up a little research for me on this conference today. And part of that research is that if you're over 65, you will live 14.2 more years, which means I will be to 84. You can feel very comfortable in re-electing me to this next term because I will still be alive. I'm going to share just a few experiences about what it's like to age and some of the things that you will need to consider, and then kind of wrap up with what our responsibility is at Bexar County and in the role that we play in trying to provide good medical services and health care benefits for people throughout the community. Let me just start with checkups. My wife, Tracy, has more doctors than I've got friends. She gets checks up all the time, and that's good, but sometimes it can lead to great confusion. I've got sort of a rule of man's a little bit different. You know, we have a hard time recognizing that something may be wrong with us, and it's our wives that usually save us by making us go to the doctor. But I've got like I say, men, I've got a little different deal. I think you're hearing from Dr. Ian Thompson today, who is a great plumber, and and men have plumbing problems. I don't know why God did this, but they gave us a prostate. Totally no need for it, but it leads to great complications for men later in life because about 85% of men, that prostate will grow and it'll squeeze your urethra tube. And so he's a critical doctor, and for all men, I would suggest that you you be sure and get those checkups, because things can go wrong, and there is a divided legal opinion in the medical community about what steps to take, but you have those choices. So to me, that's an important one that I have to keep up with. Believe it or not, politicians have hearts, and that's always a big problem with us. So it's good to go to a heart doctor. Dr. Schnitzler has been mine for a long time. I hate going there because I hate checkups. I don't want to walk in one day and say, you got a year to live or 5 years to live. So Tracy usually has to drag me to go over there. But it's a good thing to do because it keeps me on my toes in terms of what I need to do to keep up with respect to keeping this thing pumping good. I also go mostly, and this is where I think most people lose their sense of how important dental hygiene is and what can go wrong and the infections that can create there and lead to other very serious injuries. And so I've had to do some of that, I guess, making up for some of the things I should have done on dental hygiene when I was younger. I went to Dr. Buckley, very good oral surgeon. He went in, took out a bad tooth, and at the same time drained a little bit of sinus out of here down. Well, I got home for the next month or two. I couldn't get enough water in my body because it was going out my mouth as it went through the deal. I said, when will this stop? And it did eventually stop. But I would suggest very much as you're aging that you pay a great deal of attention to that. And I think we sort of measure our lifespans a little bit using our parents, you know, as sort of a benchmark. You know, those genetic makeup certainly has a big or disadvantage for you. My dad came from two very strong Germans who lived long lives, but my dad didn't take care of himself. He didn't exercise, and he loved to drink beer, you know, as a lot of Germans do. But he drank a lot of beer. We would keep up with how many beers he would drink a day. We added it all up over a lifetime, and we figured he drank 3 tanker loads of beer in a lifetime. So he died a little earlier. He died at 73.9 months. I've just, you know, got a little bit ahead of him. He also had Alzheimer's. So did my grandmother. And of course, that's always a fear when that's in your genetic makeup, that maybe that will happen to you. And so with all of these challenges that we face, it's important that 2 things happen, and really this is important for everybody. We were the first natural foods supermarket to be built in San Antonio, Texas. We actually opened up a year ahead before Whole Foods did. And the original store is still there. If you go out to Nacogdoches Road, like there by 410, it was Sun Harvest Farms. It's now, we sold the company, and it's now operating under a different name, but a lot of the same people there. I went in the other day, and Abdul, who sold bulk for us, is still there, and he was there over 20 years, so he's still selling bulk products to people, healthy bulk products, I might add. So we brought a different lifestyle to San Antonio by emphasizing natural foods, organic foods, things that you should eat that's better for your body. Now, all of us are not going to do everything exactly right. We know that. But the more you do of that, the best. Go to the Whole Foods site. I mean, they're the premier natural food company in the United States, and they provide you some wonderful services. One of those wonderful services, you can go to their site and you can see what the 100 most important foods you ought to be eating from a health standpoint. And you'll find as you read those, about half of them are produce. You know, fresh fruits and vegetables, extremely important to really get a good diet. Probably half of what you have on your plate ought to be that. And so I think it's important that you do that. As you know, we're killing ourselves purposely by eating the wrong foods, by overeating the foods. A good rule, if you go to the restaurant, every restaurant wants to kind of pile a little bit more food on your plate, maybe to get a little bit ahead of the other restaurant. There's a good rule, you ought to be eating about half of what's in front of you. And if you eat your natural foods and do really good, you'll end up dying of nothing. You'll be so healthy. The other thing that I think is just as important as what you eat is what you do with your body. And a couple of very important things are exercising. Too many people don't do that. I don't care what you want to pick to exercise on or what do you want to do, but I run at least 4 days a week. I ran this morning. If I don't run in the morning, I run 2 miles. It's enough to keep you going, you know, or do at least 20 minutes. At least keeps you going and kind of helps your mental outlook on things too, as those little dolphins make their way up to your brain and make you feel better mentally. So I think that's extremely important to do. Enough people don't do that. And as you know, obesity is one of the worst things that's happening to us today. And I hate to say it, but government is subsidized in terms of helping to kill ourselves with what they do in the agriculture products and what they do in our schools, feeding terrible things to our kids in school. So I would say those two things are important to do. And I think most important, you need to realize that when you get older, you're going to have pain. There's no way you're going to get around that. No way you're going to get around that. And you got to learn how to live with it. I've got my pains. My wife's got her pains. Good thing about that is when you have the pains, you know you're alive. You know things are happening. So get ready. Get ready for that. And so let me follow up on a couple of what I think are some very important things to do. And part of that, I wanted to mention Brian Bayless, too. I don't know whether any of you have been to the Whitty Museum, the exhibit that he put together for the UT Health Science Center on our bodies and how people can go in there and really, you know, get reacquainted with what's inside of them. A lot of us kind of know that, but then we kind of forget. And you kind of go back and see all the parts that you got to keep moving. And they do a wonderful exhibit there. I think they've had over 100,000 people come through there, and it's just as good for young people as it is for adults to be able to go see that. Our greatest responsibility as Bexar County is health care. The Bexar County Commissioners Court appoints the 7 members of the Board of doing business as University Hospital. We approve their budget and we approve their tax rate. And in 2008, we made a very big decision to expand right at $900 million, the Commissioners Court did, to build a new hospital that you see out at the Medical Center, a state-of-the-art hospital, best of technology in the hospital, and then also build another 6-story building downtown, an ambulatory center, clinic center, pharmacy. And so those are 2 huge investments that we made just recently. There's over 6,000 people working for our hospital system today, and George Hernandez is the president of it. We have 1,000 physicians, all associated with the University of Texas Health Science Center. We believe some of the very best physicians in the city of San Antonio. So it's a very important element. We're going to have a major healthcare conference. I think it's coming up September 23rd? 22nd, coming up 22nd. I had one of those when I first came in as we face problems. We're facing other issues now. Expanded health care for people is one of the big issues. So we're going to take that, we're going to take up, I think, 4 major issues on we've been working through the summer for it on this Monday and have a package ready for the Texas legislature that we hope to build support for that impacts health care in a great way. We also are responsible for the Center for Healthcare Services. We appoint their board and approve their budget. They deal with some very, very tough issues dealing with mental health that we have now, over the years, put to a higher plane. Part of the problem is if you do have a mental issue, it's going to affect your body because you're going to get depressed, you're going to have the down times, and you're not going to take care of yourself right. We expand our scope, and many times that deals over with drugs. And so we've expanded our scope in Bexar County. The Commissioners Court has established three drug courts, a mental health court, a veterans court, a DWI court, and in terms of trying to save people and help them with their health needs, whether it's a drug addiction or mental or whatever it is, instead of throwing them in jail. We've been successful at that. When I took office 13 years ago, we've probably added close to 400,000 more people in Bexar County. people in jail today than we did when I took office, because we're trying to take care of people rather than hurt them. Creating a mental health division that will be at the entry point, CMAG, where we will again try to identify more people that may have a problem and take them there. A couple of very important programs that are occurring. I think Barbara's you're going to talk to him in a little while. Is Polly here with you today too? There she is. Polly has been instrumental in a number of issues, and so I think, are you running for Polly's? Polly is retiring, and so Barbara would be taking her place. And Polly has been a great leader on working with us on many mental health issues, and so she came to us this year about a guardianship, and this falls over into legal issues that we face. And so we put into our budget this year for 3 staff positions to serve as guardians in the absence of a family member, or other willing individuals to serve as guardians of legally and functionally incapacitated individuals, and many of them being elderly. I want to thank the UT Health Science Center, first of all, for what they did out at the Institute in Aging Studies. I'm waiting for the breakthrough that will take us to 84 to 94. And they're also doing a very, very good jobs with their South Texas Geriatric Education Center. Also at the Health Science Center in the past 3 decades has improved patient care for the elderly and focused on medical concerns, particularly in the Mexican-American community here in San Antonio. So I know you'll be looking at medical issues, looking at the aging issue, looking at legal issues. Anything that comes out of this conference that you think we ought to fold into the healthcare conference, because we're going to be going to the legislature with those issues. And so about 400 people or so there. Be sure and let us know that, so we include that on the agenda. Do you want to say something?
This isn't a political gathering, but I think it would be important to mention that both of the people who are running for my bench, Barbara Scharf-Zeldis and Kelly Cross, are both here, and I'm sure they'd be glad to talk to you all about this.
All right, we definitely want to thank Judge Nelson Wolff for coming out today. Thank you very much. Appreciate it. And of course, all the hard work that the county does. I don't think I have ever gotten to cut you off before, Judge Spencer. That was, I'm going to say, a little scary, but a little empowering at the same time. I got to tell her to stop talking. Wow. I know the feeling. Talking and hand it over to
Helen. Well, I did want to thank our distinguished panel that was here this morning. I thank you for your time. Trey, Amy, Honorable Judge Spencer. I learned a lot. I hope you all did too. At this time, we'd like to take a small break. We're due back here at 10:30. Judge Wolff, 10:25.
We're due back at 10:30. Let's say 10:35.
We're going to say 10:35. Okay. So go network, meet some of the vendors that are here sponsoring our course today, get something to drink, and come on back at 10:35.